I have published two new posts discussing my trade since my last video here at YouTube. The last post was published earlier today, August 4th, 2026. A link to my blog post can be found in my profile section here at YouTube. I have been publishing them since October 2008. I'm currently publishing new posts each Tuesday. I noted in today's post that the dividend yield on the S&P 500 was 1.06% yesterday, which is at an all-time low going back to 1871. I linked a chart in that post that has the dividend yield of the S&P 500. A 1.06 yield takes about 65.74 years of compounding for money to double at that yield, and that would be unadjusted for taxes and inflation. Many of the S&P components will, of course, be raising their dividends over that period, but nowhere near enough to produce a real after-tax return for a very long time when the starting point is 1.06% now. And I do not have the luxury of waiting for the tax-adjusted dividend yield to produce a real rate of return for me. I am selling some stocks with better than average dividends into rallies, primarily in the equity real estate investment trust sector, that's REITs. By equity REITs, I'm referring to those companies that own real estate as distinguished from REITs that own paper assets like mortgages. I'm selling only my highest cost shares using whatever cost method achieves that result. That strategy reduces my average cost per share, increases my dividend yield as a result, and reduces my dollar exposure to stocks. As I increase my allocation to investment grade corporate bonds that are looking more attractive to me now, given the alternatives available in dividend paying stocks, and those will have higher yields than the common stocks from the same issuer. This is a very tough market for a dividend investor like myself. I am buying about 20,000 in principal amount of short-term corporate bonds each week, and those will be maturing in 2027 to 2029, with a few maturing thereafter, but a very limited number of later maturities. And I'm supplementing that income generation from those bonds with purchases of 6-month Treasury bills that mature in 2027. That is being done since the purchase of those bills, when I hold it to maturity, will not result in a tax on the interest income until the bill matures in 2027. It is extremely relevant that I live in Tennessee that does not have a state income tax, so the after-tax yield for corporate and Treasury interest payments will be the same for me. That would not be the case for anybody buying corporate bonds on a taxable account in states that have a state income tax. The stock and bond rally today are based on the Treasury Secretary Bessent saying that a deal to reopen the Strait of Hormuz is imminent. There is no doubt, and hasn't been any doubt in my mind, that Iran will cease attacking ships, provided all the interested parties agree to let it charge service fees, the rebranded name for tolls. I doubt that investors care about tolls being charged and levied on the cargo passing through the strait, as long as the strait is reopened for all shipping traffic. If fees are to be collected, and that is going to be a long-term issue, since Iran would be in a better financial condition as a result than it was prior to the war. I wanted to discuss the two Republican senators, Tillis and Cornyn, agreeing to vote for Todd Blanche after he signed a document saying, in effect, that the weaponization fund was dead. That document is meaningless unless Trump agrees in writing to the modifications set out therein. The settlement agreement is a contract, and it creates obligations of both parties to do. And one of the provisions in the contract is that any modification must be in writing and signed by both parties. I included a copy of that one sentence provision from the settlement agreement in my blog post today. This kind of provision is primarily designed to prevent one party from claiming that there was a verbal modification of a contract. The Blanche statement in a written document or verbally that changes the terms of the settlement agreement is nothing more or less than an admission against the government that the government is violating the settlement agreement by refusing to set up what Trump calls the weaponization fund for his allies. If Trump doesn't agree in writing to that modification, then what Blanche has done is only admit that the government has violated its agreement with Trump. When and if Trump chooses to sue the government for breach of contract and seek specific performance of the government's obligations under that settlement agreement, setting up the monetization fund for Trump allies, he will win, since he had not agreed to any modifications which was required by the terms of the settlement agreement in writing. At least he has not, as of now, agreed to those changes in writing, and he has expressed an intent that he does not intend to do so. So he could obtain a judgment down the road that would require the government to specifically perform its obligations, which would involve creating a fund of up to $1.776 billion and then to pay out that taxpayer money to Trump allies, even though they have no civil judgments against the government, and many of whom had committed criminal acts, and without even having to file a lawsuit alleging some deprivation of rights or damage, and no prospects of winning the lawsuit, even if one was filed by them. So it's just free money to them. The weaponization fund and the immunity from tax audits for those persons and entities specified in the agreement was, as the district court recently concluded, was the result of collusion and bad faith with no case or controversy, since both sides of the lawsuit were controlled by Trump. And the whole transaction was made far worse by the government being represented in this negotiations by Trump's former attorney, signing off on the agreement, and another DOJ lawyer involved in the negotiations had at least one former client benefiting from the weaponization fund. I do not read the court's order as blocking the slush fund for Trump's allies, and Trump has appealed that order. If Trump loses the appeal, it is possible that subsequent litigation on whether Trump can compel the government to perform its agreement may be in doubt. And also the DOJ's interpretation of the broad immunity from tax audit agreement, part of the agreement for Trump, his family members, and related entities, is also null and void and has no legal effect to the extent that it differs from the terms of the settlement agreement, and it appears to do so. And particularly on the firms and the persons and firms that are covered by this broad grant from subsequent IRS audits and ones that were underway at the time the deal was signed. Trump received a corrupt settlement of his claim against the IRS. There's no doubt in my mind about that. Anyone looking at it in an unbiased manner would come to the same conclusion. When the Republican senators confirmed Blanche as the Attorney General, and having previously refused to pass legislation voiding the settlement agreement and the weaponization fund, then all of them have, in effect, placed their stamp of approval on this abomination. Trump's lawsuit against the IRS would have probably been dismissed since it was filed more than 2 years after the statute of limitations had expired for lawsuits relating to the unauthorized disclosure of tax returns. His DOJ did not plead that affirmative defense in the lawsuit. They settled it before there could be a court could address that affirmative defense and its validity. Even if the statute of limitations affirmative defense had not been successful, if the case had been pursued, the damages awarded to Trump and the other plaintiffs, if the lawsuit had succeeded, would have been at best minimal. The IRS did not release Trump's tax returns or those filed by many other wealthy individuals, but they were released by an independent contractor who was charged and convicted for releasing those returns. In other words, even if all the defenses were found to be inapplicable to the lawsuit that Trump had filed against the IRS, he would have recovered almost nothing, if anything.